like I was saying though, yeah, I'm not gonna give them a lot of room at all to wiggle out of. They, because it's become apparent to me that it, none of these people in here know what is going on, except for the judge. And the judge is going to act like he or she does not know what is going on. And it's really, really just a strange position to be in. So, just because of the response of those people in there from when I asked the judge, are you allowed to sit in on cases, where you can make money? And the reaction I got from people, I had to go recheck for myself because that's what they do. They make you feel unsure, like, man, am I right? You know what I mean? You just got to go back and check up. But sure enough, though, I was correct in what I was insinuating. And again, what I was saying was you are not allowed to sit in on cases where you have a financial interest because this is not a real court case. This is administering of a financial arrangement with the executive branch of government. And you're just a part of it, but you didn't take your robe off and you didn't leave your courtroom. And you act like you are actually enforcing law. You do all the same things you do when you're enforcing law. So it's crazy. But here it is right here. Where are we at? 42 USC under 654, the state plan for child and spousal support. And that's where it tells you that now this is the plan for child support. So anything having to do with child support is going to have to come through this because this is the state plan. It doesn't say part of or part one. It's right here. And then it's going to talk about things that a state plan for child support must do. So we know that if there's something in here that they're not doing, we can call them on, well, that they're supposed to be doing it according to the law right here. And one of the first things it tells you, 3, the establishment of or designation of a single and separate organizational unit. Like Amen said a million times, organization. So it's a business. That's, doesn't say anything about anything having to do with the law or a judge, or it's talking about an organization here. And then it says that organization within the state is going to administer the plan. And then it talks about right here, this is where it shows that they are getting compensated for this. Provide for entering into cooperative arrangements with appropriate courts and law enforcement officials and Indian tribes, tribal organizations to assist the agency administering the plan. That plan, again, the child support plan, by what agency? That single and separate organizational unit, that business, that agency, and they're going to be assisted by the courts. Oh, there's your separation of powers right there. Also, it says including the entering into financial arrangements with such courts and officials in order to assure optimum results under such program. You never see anything about any law, any adjudicating of law, nothing. You talk here a lot about plans and programs and agencies and money. And none of that stuff is supposed to be involved when laws is supposed to be going on. So anyways, there's that statute right there. When you break it down properly, that's telling you that a judge who works for the court, whether that arrangement is directly with the judge or with the court, it doesn't matter. The judge works for the court. There's gonna be pressure, whether he wants to do it or not, whether he's willing. He's got bosses too, and he's gonna have pressure to make sure he's doing this correctly, and he's getting this money for the state. And it all works for everybody. Like Like it's been pointed out, it goes to the Treasury. I guess the more that's in the Treasury, the more that's available for them. I'm not exactly sure that's divvied out, but it definitely doesn't hurt. It at the very least provides more security for all of them to make sure that there's money always there. And that shouldn't have any bearing on a court case. Here, excuse me, is what I wanted to show you guys. So if you guys read Holmberg versus Holmberg, you'll find out, if you really read it thoroughly, you'll find out that child support is separation of powers. They actually kind of explain it, even though they act as if, but we're going to change it. But we're going to change it, though. You can't change it. There's no way, because that child support law is based off other laws, and that's how the law has it set up. It's not set up to be adjudicated by a actual judge. It's supposed to be administered through an executive agency, plain and simple. But this is the most money-making way and effective way to do it, to scare people through these fake proceedings. Let's see here. So yes, I just wanted to show you this. Let's see. Where is it? This is the Advisory Committee on the Rules of the Expedited Child Support Process. This is after the case. And it's, let's see here. Let's see what this says. In 1995, Michigan legislature enacted Minnesota statutes requiring implementation in each county of an administrative child support process to resolve child support matters involving the public authority. Okay, here it is. On January 28, 1999, the Minnesota Supreme Court issued its decision in Holmberg v. Holmberg, holding that the structure of the administrative child support process violates the constitutional constraints on the separation of powers in 3 ways. The administrative process infringes on the district court's jurisdiction in contravention of the Minnesota Constitution, Article 6, Section 1. Administrative law judge. Remember I was talking about kept saying administrative law judge? Administrative law judge jurisdiction is not inferior to the district court's jurisdiction as mandated by Minnesota Constitution. And, it goes on here. But there's more I want to show you. There's some crazy stuff in here. So this obviously, basically what this is a response to correct the legislation for child support statutes and the regulations of how they're going to execute it, so that they will be following the Constitution, basically, or it'll be legit. Let me see what they're calling them here. The Advisory Committee respectfully makes the following recommendations to the Minnesota Supreme Court. It's all about recommendation. There's never any concrete, hard, firm orders or anything going on here, but it's all a bunch of recommendations and this and that. It's just crazy when you pay attention to all the nonsense. Let's see. And this is explaining how the Supreme Court's coming up with these rules. Will promulgate the proposed expedited child support process. And then let's see here. What does it say? It's telling you when it's going to be effective. So this is throughout this whole thing, you're going to see a lot about what do they call them? Child support magistrates. Let's see here. Okay, so here, this is all about the proposed expedited child support process rules. So they're proposing it. Anyways, it's got definitions in here, and that's where I think I want to go first, to the definitions. But these are the rules here. So these are the new guidelines that they're going to tell them they have to follow, so that they're in line with the Constitution. See right here. These rules govern the procedure for all proceedings conducted in the expedited child support process, regardless of whether the presiding officer is a child support magistrate, family court referee, or district court judge. To the extent that the rules of the court are inconsistent with these rules supersede. So at the top it's talking about all proposals and suggestions and all that. Now it's saying, okay, these are the rules that are governing the new child support procedures. Here we go. This is telling you now. Number 2. What is this? Okay, that's not what I'm looking for. Let's see. Definitions. Look at this definition right here, guys. Child support magistrate. Okay. What does it mean? Any individual appointed by the chief judge. So appointed by a judge, not a judge. Okay, so we still don't have a judge. Okay. Of the judicial district to preside over matters. Okay, so this person appointed by a judge but not a judge is going to preside over matters and expedite the child support process. Okay. Still, we haven't seen evidence of a judge. Okay. Child support magistrate also means any family court referee or district court judge presiding over matters in the expedited child support process. So guys, now the first thing I'm going to say is I don't know if these are still the standing rules. What I'm trying to prove is that see how fraudulent these people are and how they're always going to try to make it seem like they did something, but it's just all, what do they call it? Fog and mirrors or whatever. They claimed they declared child support unconstitutional. They had to fix it so that they can keep getting their money. So they have these new set of rules here. But the whole problem of it is that there's no real judge involved. That's one of the major issues, being adjudicated by executive branch members. So, okay, that's why I'm saying no evidence yet of a judge. Just this child support magistrate, okay, and who he's appointed by and what he's going to be doing. Okay, and then so now we know when it says right here, because this is pretty much lining out who's going to be able to do this. It says regardless of whether the presiding officer is a child support magistrate, family court referee, or district court judge. So it tries to separate them as if they are different people, but they are not, because under the definitions, a child support magistrate also means any family court referee or district court judge presiding over matters in the expedited child support process. Which is, the expedited child support process pretty much encompasses everything that happens in child support. So, there you go. I mean, they didn't do anything. They just made it seem like they did. Here we go. Under the administration of the expedited process. That's what these child support magistrates are supposed to be doing. That's number 10. Right here again, let's see. The chief judge of each judicial district must determine whether the district will administer the expedited child support process within the judicial district in whole or in part, or request that the state court administrator administer the expedited child support process in whole or in part for the district. They're always making it seem like a big decision's being made here. It's just some bull. It's nothing. Just act like they're just writing stuff down that doesn't matter, just to throw you off of the really important information. And it goes on some more. Let's see. The chief judge of each judicial district must determine whether the district will use child support magistrates, family court referees, or district court judges, or a combination of these individuals, to preside over proceedings in the expedited child support process. Do you see how fraudulent that is, guys? Go back if you didn't hear it. We just talked about how these three people, child support magistrate, family court referee, and district court judge, are all the same. As long as they're doing this expedited child support process, they are a child support magistrate. They are not a judge. I guarantee if you look up child support magistrate, it will not say anything about a judge. Oh man, this whole thing, guys. At first, I would find out if it's still up to date, but and then if it is, I would read it because it might still be like it very well might still be like this today, guys. And this is something you can use to tear it apart. But even if this isn't the most updated version, it's gonna be something very similar. You gotta look for the little, um, you know, fraudulent sentences or the way they write or what. When I first um, and then this will be the one shout out I will give to Wasil. When I was talking to him one time, he did say, they got a spell on you. And I understood what he said, but at the same time, I feel like it even goes deeper than that. I feel like for somebody who is just looking at these words and they're not thinking that anything bad's going on, or they haven't been made aware that there's something fraudulent going on, they're just reading it, trying to understand what's going on, they would never get it. It just the way they write it, all the bull they add in between the important things, the definitions and jumping around the big words here and there, out of order words that you've never seen before. I'm telling you, man, they really know how to put a spell on people, and I can see why some people just get stuck and it just they don't understand. This is some crazy stuff. It's really kind of disgusting, but that's one thing you guys are probably gonna have to learn to do is to read correctly, because that's the only way you're gonna be able to come back at them properly. I would say that I have a decent amount of knowledge, at least enough about child support so that I could explain to somebody what's going on. But when you're in that courtroom, they're just they're jerking you around so many different ways. It's a mess. I'll probably get back with you guys when I get my documents in the mail. Uh, you know, about the proceedings, how they went and all that, their opinion, whatever. And I'm gonna wrap it up. I might get another quick video in a little later. There was other things I want to talk about, but I think it's about time for me to wrap it up. I gotta work early tonight. So, all right, guys. I'll check y'all later.